Sigel. I'm John Kane, and this is Let's Talk Native. On this episode, I want to talk about the court system, or more specifically, about using the court system as a remedy for our conflicts with the state and federal governments. Let me start by saying that there are no specific remedies in place inside the US or Canada for these colonial powers to be held accountable for their genocide, crimes against humanity, or any of the numerous violations of the rights of Native people. There is also no process for political resolutions to our differences. And while there's plenty of talk about tribal summits and consultations, there's no meaningful dialogue or system in place to adequately address these conflicts. In 2007, when the US and Canada voted against the UN Declaration on the Rights of Indigenous Peoples, we were told that one of the main concerns was that the current remedies for conflicts with us might be undermined by the UN Declaration. When specifically asked what these remedies were, they responded with the courts. The UN Declaration on the Rights of Indigenous Peoples calls itself the minimum standard for survival and dignity. But today, not even that standard is met. As Native people, we often hear lip service about consultations over issues impacting us or our lands, but those consultations rarely occur. And the standard called for in the UN Declaration on the Rights of Indigenous Peoples is not consultation. It is free, prior, and informed consent. The US and Canadian courts cannot rule on issues of sovereignty. They are limited to only their laws and their own constitutions. They certainly can dismiss a case because they lack jurisdiction, but that would be diminishing their authority, and no court wants to do that. And while some judges and juries may be sympathetic to the arguments in favor of Native sovereignty, no judge is willing to stick his or her neck out and dismiss a case or rule in favor of a Native nation, person, or business entity based solely on the arguments of sovereignty. So when we do win in their courts, it's often a shallow win because of a backdoor ruling. Famed civil rights attorney William Kunstler, who is most known for representing the Chicago Seven, members of the American Indian Movement, and Assata Shakur, once represented me as well. I recall him telling me and those of us facing a federal trial that the key was to give the judge a way out. He said, make all your sovereignty arguments, but know that most judges will never rule on them. So make every argument you can. Give them a back door, a way out. In their courts, we are treated as one of them, and to them, we are completely subject to their laws. And while their courts can never actually pinpoint when and where they got their authority to rule over us, or more importantly, when we gave that authority to them, there have been centuries-long efforts to publicly refuse to acknowledge our distinction as a people and the distinction of our lands as independent nations. My guest this week is Jeff Reina, an attorney from Buffalo, New York. Jeff will speak with us about a recent case involving a fine of over $1 million levied against a Native wholesaler over the transportation of a Native tobacco product from one Native territory to another that was recently tossed out of court based on an illegal search and seizure after almost a decade-long legal battle. My guest is Jeff Reina, who is an attorney, and I'll let Jeff introduce himself. Jeff, first, thank you very much for joining me on the program. And if you would, give me kind of just a brief introduction on who you are and what you do.
Sure. And thank you for having me on. I appreciate it. Yes, I'm a senior partner at the law firm of Lipsitz, Green, Chimay, Cambria. It's located in Buffalo. I head up my firm's commercial litigation department. And in that role, I have represented a number of clients on Native American issues with respect to their businesses and their business operations.
Well, and of course, part of the reason that that's such a necessity is it appears that native commerce is more often than not under some sort of assault from either the state or the federal government, and not just in New York State, but certainly many places. And part of that the reason that it's under assault is because we don't completely conform to say the least, to state law, and or I should say, we don't completely acknowledge that state law applies to the things that we do on our territory and the things that we do in terms of native to native commerce.
Correct. I guess the best way to put it would be, there is an undercurrent in federal case law that suggests that native to native commercial transactions are to be encouraged, and that type of commerce is something that the federal government has an interest in promoting. But in practice, it doesn't really occur all that often in the decisions that are being handed out by the federal courts. It's much different on the state levels. The states take a much broader view of state authority and the ability to regulate native to native commerce between either tribes themselves or between members of the tribes who have established business on the reservation.
Well, and in particular, it doesn't happen on the state level. I mean, where we do on occasion, especially when some of these higher profile cases, get attention in the federal courts, we will get some legal dicta that would suggest an acknowledgement about the distinction of native peoples, native territories, native commerce. But at the state level, there's almost a complete failure especially in New York State, to recognize that we are distinct, that there are things that happen on our territory that the state does not have say over. And and the sale of tobacco is just one of those things. But I guess the first thing that I want to mention is one of the flagship cases that always gets mentioned when it comes to New York State taxing native sale of tobacco is the Atiyeh case. And so the Atiyeh brothers were a state licensed wholesaler, but they were also a wholesaler that had a federal Indian trader's license. And they argued when the state was trying to force all tobacco, that came from state wholesalers to be stamped before they came to a native territory, because we had been purchasing tobacco products without a stamp from New York State wholesalers for many years. When they tried to change that, the Atiyeh brothers sued the New York State Department of Taxation and Finance and said, we have a license from the federal government that supersedes the state law. And they lost, and then they won, and then it went all the way up to the Supreme Court. And the Supreme Court ruled that their federal Indian trader's license did not supersede state law, and they cited a couple of other examples in Colville and Potawatomi, and another case called Mo, where the state or where the federal courts had upheld that the states could impose a minimum burden on tribes to assist them in tax collection. And because that had been held up in federal court, this Supreme Court ruled against the Atiyeh brothers, saying, look, if the tribes themselves could be held to a minimum burden on tax collection, your claim that your federal Indian trader's license supersedes state law, fails. So that was the ruling, right? But in that ruling, there was language that they pulled from both Mo, Colville, and Potawatomi that brought out the very specific argument that while the state may have a right to try to pre-collect a tax on a product that we merely purchase off territory for sale on our territory to consumers that are off territory, that's completely different. And they said that stands on markedly different ground than taxing a product that Native people add value to, manufacture, distribute, market, design, whatever. So they made it very clear that, so in other words, to simplify it, it's one thing for us to buy Marlboros off territory and sell them to, John Q. White guy coming off the territory to buy it. Then that's different than us selling a native brand, a brand that native people have added value and have somehow have a vested interest in specifically to that product. And so that has been the underlying, federal law essentially based on being cited in multiple cases. Did I get any of that wrong?
No, you didn't. Yeah, because I mean, in a nutshell, what the Supreme Court was saying in the Attia case was that where the incident of the tax actually falls on the purchaser of the product, and in this case, it would be the way the regulatory framework was being set up. If you're a New York State licensed wholesaler and you're selling, stamped tobacco products to a business on, let's say, the Seneca territory, they have to the business has to prepay the tax, but then would apply for a coupon for any sales that were made to Native Americans, right? And the court looked at that framework and said, well, the regulatory burden really doesn't fall on the business that's located on the reservation. Instead, it falls on the consumer who's buying it because they're going to end up paying the tax. And it's perfectly okay for a state to regulate its wholesalers in this manner. And that's kind of where that fell. But there is language suggesting in Attia that's never really been, it's sort of more as an offhanded comment. It's not really a holding where it's binding, that, when you're talking about transactions, as you said, between Native Americans and Native Americans, that the state, New York State's interest or any other state's interest is much less. And therefore there should be some non-interference. Where we get into the issues that we're facing today is that, for example, the Seneca Nation now licenses tobacco wholesalers. So they're not New York State licensed tobacco wholesalers. But they're trying to say that in the instance where you have, a tribal wholesaler who's operates solely on territory and is selling cigarettes that are manufactured by Native American-run businesses, the state is trying to take the position that those transactions can also be taxed. But it raises that issue that has been cited in Attia and has been mentioned in some other cases where you're interfering now with not a transaction where a New York State resident is walking in to a smoke shop on the reservation and buying cigarettes that were manufactured, like you said, by Marlboro.
Or they could buy anywhere else, exactly.
Where they could buy them anywhere else, et cetera. Exactly. Now you're trying to go after the transaction where a New York State resident goes into a smoke shop and purchases a Native American produced, manufactured, and packaged product that's been sold pursuant to the laws of the Seneca Nation to a licensed wholesaler on the nation, who then turns around and sells it to a Native American retailer. And now you're trying to impose the same burden that you were trying to do on New York State licensed wholesalers. And that's where, I think there's a lot of overreach, but we just can't get the courts to fall down on that issue, on that side of the decision, and say, yeah, you're right.
It's important to point out, though, that native brands really cannot be taxed. And the reason is because they have been excluded from things like the Tobacco Settlement Act. I mean, there is really no vehicle for a native produced tobacco product to ever even get a New York State stamp on it. So they've been excluded. So so the reality is, even if native people wanted to, get a tax stamp affixed to a native brand, they couldn't do that. And of course we wouldn't want that. But the other thing that is important to point out is that the brands that we're talking about are only available, they're exclusively available by native retailers. So, again, we are talking about a product that can't be purchased anywhere else, that when they are even in transit from one native territory to another territory, they're not showing up on the streets of New York City or any place else. These are going, to be distributed to a native retailer on a native territory. And I think it's important that, because I think New York State has the highest smuggling rate of any other state in the country. And that's partially because they have the highest, tax burden on tobacco products. So it's easy for somebody to buy tobacco from another state and bring it onto the territory. I also think it's worth noting that under New York State tax law, 2 cartons or less can be brought into New York State, so even coming off of a native territory, into New York State without any tax liability. There is a limitation according to tax law, that says 2 cartons or less are exempt from New York State's excise and sales tax. So, and I think that's important that people realize that.
Correct. That is true. There is that exception.
Now, so what happens is, and as you rightly described, where we are with New York State. So you have New York State that is somewhat belligerent to acknowledge that there is any native distinction, at least officially. Unofficially, they do, but officially, they would suggest that if a native wholesaler who's licensed by their nation is transporting a product to another native territory, that they must abide by, and they must be licensed by New York State, which of course they couldn't be. I mean, they would literally be prohibited not only from being licensed by New York State, but the product that they're dealing with would also be prohibited from ever receiving a tax stamp. There's a failure by New York State to acknowledge that there's any distinction from native commerce or native to native commerce from their own, and this could not be more highlighted more distinctly than when I personally went to Albany and solicited from a New York State senator, Senator George Maziarz, who represented Western New York, and as a Republican, and New York State Senator Tim Kennedy, a Democrat from Western New York, and because there was becoming a change in the tax law, I said, can you get clarification from the New York State Department of Taxation and Finance? Because we sure as hell can't. Can you get clarification on where they stand, where the tax department stands on native brands and native to native trade? And in their letter requesting clarification, and they wanted it in writing, they said, because it's our position that New York State law does not have authority over native to native trade or over native brands. So 2 New York State senators from both parties, and this was during the Coleman administration still, I believe, and they had solicited this, tried to get an opinion out of the commissioner from the Department of Taxation and Finance. And frankly, it's been many, many years, and they never got an answer. But what did happen, about a month after that letter came out of Senator Maziarz and Kennedy to the Tax Commission, an interdepartment memo was released within the Department of Taxation and Finance, and we refer to that as the Do Not Seize letter. Now, this was not a memo that was meant for our eyes. It was distributed to taxing agents in the field, and basically it clearly laid out the distinction between native brands and native wholesalers from the happenstance that an agent would come across a truckload of, let's say, Marlboros without a tax stamp on it. And I actually got my hands on that memo from a reporter in New York City. But guys like your client, Eric White, carried that letter, that Do Not Seize memo, on their truck, along with the Kennedy and Maziarz letter, in the event that there was a question on what they should do. Because if a taxing agent or New York State Police should happen across a vehicle that had unstamped native brands on it, they could clearly see, okay, well, this is the interdepartment memo. So while the department had made this stance, they still would not answer, or as I say, promulgate their position on native to native trade or native brands. They would not make an official statement, even when 2 New York State senators requested so. And you and I have discussed this because in the interest of disclosure, Jeff, you actually had me come in as an expert witness to testify for the driver in this one case when he was facing a fine in excess of $1 million, and we'll get into more specifics later. But and we talked about things like the territory that they were delivering to, but the judge at that time gave me a lot of leeway to talk about everything from the Attia letter to the Maziarz letter to the Do Not Seize memo. Gave me a lot of latitude, and I think that judge was somewhat influenced by that. Although, as we learn with each of these cases, regardless of whether we are right or not, that's not what is going to win in these cases. These cases oftentimes turn on, and I use the advice that William Kunstler once gave us as Native people fighting for something. He says, make sure you always give them a back door, give them a way to save face. So you're probably not going to win your case based on sovereignty or jurisdiction or or your rights as a Native person. You're probably going to win this thing because a court's going to be sympathetic to all of those things, but not rule on that. They're going to consider, as as this one judge did here, that our remaining contentions have been um, uh, regarded as academic. So they'll find a loophole, they'll find a technicality to throw a case out. And in the case of the driver, who you asked me to testify in his trial, or his hearing, I should say, they dismissed his case just based solely on what the common carrier law.
Yeah, basically the truck he was driving was a contract carrier, and under the tax law, there's an exception for a contract carrier. They're not subject to the penalty if the product that they're shipping, in this case, Native American brand cigarettes, are not bearing what they consider to be the appropriate tax stamp. So that was how we won the driver's case.
So, but again, I mean, to be clear, although we always make the argument that we have certain rights to do these things, the courts are really hesitant to weigh in or to rule on what our rights may or may not be. And so essentially when they dismiss it because of a common carrier argument, the question about whether we have the right to do native to native trade still never gets answered.
That's correct. Correct. I mean, we make those arguments. We made those arguments in every case that we've ever, had to bring on behalf of either a retailer or a wholesaler on the reservation. We've made the sovereignty arguments, but when as a lawyer, my job is not only to advance the sovereignty argument on my client's behalf, but it's to make every argument I possibly could come up with for a defense in this case to a penalty that was issued. So, my job is to come up with as many viable defenses as I can and try to win on, one or more of them. But like you said, these types of cases where you've got these sovereignty issues where a judge is going to have to sort of stick their head out and say, yeah, sovereignty trumps what New York State's trying to do in this instance. There is a reluctance to do that if they can win through, as you said, a backdoor argument. In the first case with the driver, that was the common carrier exception. And in another case involving that same transaction, it was a different backdoor. So it just seems, and that was declaring the entire search and seizure illegal. And then therefore there's no evidence of transportation. So therefore the whole case goes
Well,
away.
let's back that up a little bit. Describe what the transaction was, just so for those who are listening here, know what we're really talking about here.
All right. So the driver, it was a licensed wholesale business on the Seneca Nation, duly licensed under the laws of the Seneca Nation of Indians. An order was placed for a number of cartons of cases of cigarettes to be transferred from the Seneca Nation to and I'm going to mispronounce the name because I always do, the Ganunka territory.
Well, originally, but it was actually purchased in Akwesasne, right, by Oyonkwe Trading in Akwesasne, right? Isn't that where the...
No, Oyonkwe Trading put the order in to the wholesaler on the Seneca Nation, and then it went from there to the Ganunka to the retail. All right. So the driver was driving the truck down the interstate and missed a safety inspection point, and the police pulled him over and had him go back to the safety inspection point. A safety inspection was conducted on the vehicle. After the safety investigation was concluded, they held the driver for a number of hours while they decided if they were going to try and search the vehicle. The vehicle was locked. The back of the vehicle was locked. The driver didn't have the key or couldn't locate the key and didn't give the police permission to open the back of the truck. Nevertheless, they ultimately decided they were going to go forward with that. So they cut the bolt, the lock and the chain, and opened it up. And what they saw were cases. And on the bill of lading and other paperwork that the driver had given to the safety inspectors, it had said that they were cigarettes, but it didn't say if they were stamped or not. So they knew what was in the cartons. They just didn't know what they looked like. And so then they went in, they opened the box, or the case of cigarettes. They went in and they opened up the box and they pulled out a pack. And then they determined, well, they're not stamped. Therefore, in their opinion, they were illegal. So they seized the cigarettes, never arrested the driver, cited the driver for a few minor safety issues with respect to the vehicle, and then he was sent on his way. And after that, what the state did, what the State Department of Taxation and Finance did, was it imposed fines or penalties against the manufacturer of the cigarettes, which was King Mountain. It was approximately $1.2 million in a fine. Against the driver for $1.2 million, against the wholesaler for $1.2 million, and against the retailer who was supposed to receive the cigarettes. And we were successful in fighting that ultimately on behalf of both the driver and the wholesaler. It took a lot of time, effort, and a considerable amount of money on my client's part to be able to defend and succeed on this case. But we were able to get those penalties removed against the driver and the wholesaler. And then King Mountain itself, my understanding is, was also successful on the common carrier exception in getting that penalty removed from it. I don't know if the retailer ever challenged it. I don't think they did, but that's kind of where it ended up.
Yeah. A native brand tobacco product was shipped from Seneca Territory to Mohawk Territory. Native driver, native wholesaler, native common carrier. And for all intents and purposes, even the wholesaler at that point was not necessarily considered the owner of that product. So the common carrier argument worked for the driver, but it did not work for the wholesaler and the individual who owned the wholesaler.
Right.
Now, and again, to be clear, the argument about an illegal search and seizure was made back when it was just a revenue department hearing through the state trial and ultimately to the state appeals court. So
right.
You made the same argument, but again, depending on who the judge is, you don't know. There's no telling what ruling that a judge is going to make. And in fact, the same common carrier argument that you had argued for the release of the driver's penalty. When you tried to make that argument for the wholesaler, is it wrong for me to suggest that the judge actually introduced arguments against that the state hadn't introduced?
That's correct. So the way just procedurally how this works, all right? So you get assessed a penalty, you file a petition objecting to the penalty, you ultimately get a hearing in front of an administrative law judge, an ALJ, that works for the Department of Taxation and Finance. And then you put on a case, an administrative hearing, and the ALJ will make a decision. And then if you don't like the ALJ's decision, you can appeal it to the tax tribunal, which is the next step in the process. And then if you don't like the decision that comes out of the tax tribunal, and this again is still administrative, this isn't a court, it's a panel that's appointed and works for the Department of Taxation and Finance.
But are these judges, people who serve as a judge in other capacities?
They serve as administrative law judges for the department, all right? But they still they work with the department primarily. So you obviously go in there with a little bit of skepticism. Sometimes you win, sometimes you lose. But if you lose and you want to appeal it, then you take it to, you don't go to a trial level court like a New York State Supreme Court. That's our lowest level of courts in New York State. You go to the appellate court that sits above the Supreme Court, which in this case was in the third department of New York State, and you make your appeal directly there of the of the tax tribunal's decision, which is what we did. But what was interesting is we have two separate cases that were conducted. We have the one against the driver, which went first, which is the one that you testified and was very helpful in terms of getting that decision. But in that case, the ALJ that was assigned to it said that the truck and the driver were acting as common carriers, and therefore there's an exception to liability under the tax law, and therefore the imposition of the penalty against the driver was improper and voided the penalty. We made that same argument in front of a different ALJ who heard the wholesaler's case. And if you look at the decision, he agreed that we were acting as a carrier of the cigarettes, but he rejected that we fell within the common carrier exception because, in his opinion, the transportation of the unstamped Native American brand cigarettes violated Public Health Law Section 1399. I think it's dash double L, I believe, which requires that the recipient must be licensed or registered as an agent or dealer under Article 20 of the tax law, which was never, that argument, the public health law argument, was not argued by the Department of Taxation and Finance at the hearing or any of it in its post-hearing briefs. That was something that the judge sort of went out on a limb and came up with that argument to argue that we weren't lawfully transporting cigarettes, therefore we do not get the benefit of the common carrier exception. And one of the arguments that we raised on appeal, which the court didn't opine on, but that argument was presented, was judges aren't supposed to do that. Judges are limited to the arguments and the replies they're put in by the attorneys. The courts are not supposed to go out and look for arguments that haven't been fully briefed, which is what this ALJ did. So that was particularly upsetting to us, and so we challenged the decision on that basis as well. At the tax tribunal level, they agreed with the ALJ, and then we made that same argument to the third department. But the third department, again, in the wholesaler's case, kind of short-circuited all that by saying that the initial search and seizure was unlawful, and therefore, there's no penalty because there's no evidence of the unlawful transportation of cigarettes, because that evidence is basically stricken. And if you don't have the cigarettes, you don't have a case.
Speaking to the whole to my friend who is actually the wholesaler, he actually sponsors the show, again in the interest of disclosure. One of the things that upset him was just that you actually are not arguing your case against the state's case. You've actually got a judge not sitting as blind justice, as an equal arbiter of these two arguments. You're actually arguing against the judge himself. And
Right.
And that is problematic because you no longer have somebody who's sitting there hearing the case and then making a ruling based on the merit of each argument. He's already prejudiced to the extent that he's building his own case against you. That's a whole nother level of really absurdity if when you really consider it.
Yeah, and as a lawyer, my partners and I, we were pretty incensed that occurred, because obviously we took pride in the arguments that we were making and in the reply to the opposition that was interposed by the Department of Taxation and Finance. And then we were effectively blindsided by this legal argument, which we were never given an opportunity to address. And so, that was particularly problematic, and it indicated to us that there might have been some bias on the part of the ALJ. But we have to keep going and moving forward, and that's why we ended up all the way at the third department.
Yeah, and look, I still come back to what really ends up being the problem, which is, I go back to the Maziarz Kennedy letter. When you cannot get the state to properly address any of these issues, and they asked a very simple question. They basically asked the New York State Department of Taxation and Finance, what is your policy on native brands and native to native trade? And that refusal to answer, to me, and I'm not a lawyer, but to me, the fact that the state would actually refuse to answer that question should somehow prejudice their ability to prosecute a violation of state law when they have been presented with that question time and time again and literally refuse, not just fail to answer it, but they refuse to answer that question.
Yeah, it's a function of the way governmental bodies work. Unless there's a regulation that's promulgated or there's a law that says this is how you're supposed to handle things, an agency is reluctant to go on record as saying this is our policy. But even in this case, because we did raise I believe it was the driver's case, the issue of this, statement that came out, this internal memoranda saying that, it was the non-seizure letter, however you phrased it. The response to that was, well, that's just an internal policy and those policies change. and nobody should have relied on this anyway because it wasn't supposed to be given to anybody other than people within the department. So their point is we have administrative discretion to change our policies if we deem it, and we're not obligated to follow a policy that was promulgated, a few years prior. We've determined that we're going to do something else. So,
but they never have to produce any information that really suggests that they actually did change policy, and that's where we have a problem. It seems to me that anybody who is going to be held accountable to a law, a regulation, or whatever, some sort of legal restriction, they should have the opportunity to know that what they're being charged was officially stated, that it was promulgated. I mean, is anybody supposed to know that they're committing an unlawful act if the very agencies who are suggesting they are unlawful won't come right out and say what the policy is?
No, I agree with you. But New York State has this penchant for doing things in an opaque manner and not being clear with things because I think they think it gives them some wiggle room in terms of the more problematic cases that they bring. So, the fact that there's not clarity is not surprising. Is it problematic? Yes. And it's for the same reasons you just mentioned. A person isn't on notice of whether or not they're violating the law if they can't get a statement from the enforcement agency as to what they interpret the law to mean. So, I would agree with you that in this particular instance, having that memo and relying upon that memo prejudice my client's rights because apparently they decided at some point subsequent to that internal memo being circulated that they were going to start seizing these cigarettes.
Well, and that subsequent decision might have been made on this very transaction, and that's the problem, right?
It could have been. It took them an awful long time to figure out what they were going to do. It was several hours. I think it was in excess of 3 hours before they figured out what they wanted to do. And once they broke open the truck, they had them drive over to I believe it was the New York State Police barracks, closest one. They offloaded the cigarettes and then let the driver go. So I think that they were on the phone talking to higher ups, and I think a decision was made. Yeah, let's seize them to try and use this as a test case. I don't have any proof of that, but that's my own opinion on it.
So where it comes down to, and and look, I have a history of confronting some of these issues with both the federal government and state government on what remedies do Native people have to confront some of these actions of the state or the federal government. And one of the things when there was the argument going on about the UN Declaration on the Rights of Indigenous Peoples, there was a debate, and this is during the Bush administration, that the reason that the United States would vote against that UN declaration was that they were afraid that international law would be changed. And more specifically, the remedy that the United States currently had been using to address conflicts with Native people. And during the Obama administration, this goes back to 2010, they had enlisted the State Department to host a series of consultations with Native peoples, including leadership and NGOs, to re-examine what the United States position would be on the UN Declaration on the Rights of Indigenous Peoples. And I went to that. I was in Washington, and I listened in on the one that had the so-called leadership, and then the one that allowed the rest of us, the NGOs as we were called, to participate. I was a part of that as well. And they kept referring to, again, this upsetting the current remedy. So finally, I got a chance to ask a few questions, and I said, so what exactly is this remedy that you keep talking about? And they said, well, our court system. And I said, so you're going to try to tell me that your courts, your judges enforcing your laws are the remedy for us to deal with conflicts over your laws in your system? And they said, yes. And so my point to you, and for having you come join me today, is to make very clear that the court system is not a place to deal. It is not a remedy. It is not any kind of. It's not an administrative remedy. It's not a judicial remedy to address Native issues. Because at the end of the day, The native arguments weren't ever what gets considered in this thing. You actually have to find a place, again, in the words of somebody like Bill Kunstler, you've got to find a place that these judges can slip through to give, because if we do win a level of sympathy from a judge or a panel of judges, they're still not going to rule on the native issues. They're going to find the common carrier argument. They're going to find the illegal search and seizure argument. So it is by no means a any kind of remedy for us to deal with the conflicts that we have with the state or the federal government.
Yeah, well, I agree. But we're limited in terms of what recourse we have, right? You can either petition the government to enforce laws. You can or you can go to the courts, right? And those are as a New York State attorney, those are the only avenues that are available to me. And I agree with you, though. The remedies themselves, or the avenue of remedies, are ones that have shown repeatedly that the heavier issue of what exactly the rights of a sovereign people are vis-a-vis the state of New York are oftentimes just left undecided because they find a more convenient way to give the petitioner, the Native American who's involved in the case, or defendant, depending on what's going on. But the Native American arguments that are being raised on behalf of that particular person, they tend to, while they're there, and they may be sympathetic to them. I agree with you. If there's another way, an alternative way to grant the relief, that's the way they're going to go. They don't want to take on the heavy issue of, am I going to tell New York State it can't interfere with this type of transaction because this is a sovereign transaction? This is a transaction between sovereign peoples that the state has no interest in interfering with, and they just don't. They have a reluctance to do that.
Even when, and I agree that when we talked about that piece from Attia that talked about the state standing on different ground when they're enforcing their tax law to their end user, by imposing the tax on the New York State wholesaler, or having the New York State wholesaler, that's different than trying to tax us on an activity we specifically are involved in. But that argument that was presented, or that language that was presented in Attia, has been presented in several other cases involving specifically tobacco and taxation. So it wouldn't have been a stretch for a judge to say, yes, what you're going after here, there is some legal language, there is some legal dicta that addresses it. So so that reluctancy really puts us back to what essentially what I said, that the courts fail to be a remedy for us to address specifically our issues of sovereignty or native rights. We only can make those arguments alongside some other argument where they fail to properly enforce or use a New York State law, for instance. So we don't have any remedy, and even today, with the UN Declaration of the Rights of Indigenous Peoples widely endorsed, at least from an aspirational standpoint, there's still no other remedy. We don't really have even the opportunity to really petition law enforcement or taxing authorities or politicians. Look, when you get two New York State senators asking a simple question on this specific issue and they can't get an answer, if they can't, if two white guys elected into office can't get an answer, what's the chances of a Native person petitioning, the taxation department or the governor or anybody else?
Yeah, no, I agree. So, I don't know. There is no easy answer to say, where do we get these issues heard? I mean, the only place they can be heard where it would make any difference would be the courts, and like we discussed, the courts are reluctant to come down on the side of sovereignty. So we're kind of stuck in a catch-22.
Yeah, and I do agree, though. I think making those arguments can sometimes at least skew a judge or a panel of judges to look for that other way out, but that's still not the same. So what ends up happening is the guy who's facing the fine might come out of this thing not having to pay the fine. But we as a people, we never win. We never win these bigger arguments. And of course, oftentimes we are in a situation where we have to, cut our losses. I mean, in this situation, didn't your client have to put up the full value of the fine in advance just to even make the argument?
Yes, yes. So that's a quirk in tax law that happens. So if you're assessed a penalty, or you are audited and you're told you have to pay more in taxes and with fines and interest and everything else, in order to get your case heard, you actually have to pay it or deposit that money uh, with the department in advance of making the arguments that you shouldn't have to pay the money, so that when you win, you have to ask for the money back. And that's the way it's set up for. I mean, that applies to everybody that ever wants to challenge in courts these actions by the Department of Taxation and Finance, whether it's a penalty imposed in this particular instance, or it's a tax, additional taxes you say you owe, but you don't really don't think you owe them, and you want to challenge that determination. So you got to pay it into the court, or pay it into the department, and then they'll issue a refund once you win.
So so much for that innocent until proven guilty thing, right?
Yeah, exactly.
In fact, they're so concerned about getting paid that they make you pay up front, so you have no other, you can't lose and then claim you don't have the resources to pay it. They make you pay it up front.
Yeah, exactly,
Yeah,
exactly.
well, that is and again, that's to say any of this stuff. I want to be clear. It's not like they are violating or much of this is is the policy they have towards anybody. The problem is there is a distinction. And, not only do we get a couple of state senators acknowledging that distinction, but we do get that acknowledgement in some of these court cases. But at the end of the day, when it comes down to at the state level, they know that look, they've got legions of state troopers, they've got taxing agents, they've got a whole system built up that really is all geared towards us not ever really seeing justice. And the fact that you had to go through these administrative hearings, a series of those, and I suspect that there's probably not a whole lot of recourse for your client to not only get the let's not forget, there's probably $150,000 worth of tobacco that he was basically taken from illegally.
Correct. Well, in our case, we had argued as part of the common carrier exception that title to the cigarettes had passed to the buyer. We were just transporting them, but somebody is out those cigarettes. Let's put it that way.
Right. And is there any recourse for your client to to try to recover any of the? I'm sure it must have been and this isn't a slight on you, but you guys don't work cheap. I mean, I know these are difficult cases to try, and you guys have to commit an awful lot of your resources as as lawyers. So, does he have any opportunity for relief from the legal expenses?
We're looking into that right now. With respect to the administrative hearings and things, like for example, the case involving the driver, we were able to get some of the attorney's fees back from the state. We were able to make that application. What we're looking at now is whether or not, because we had to appeal all the way up to the third department, whether or not we can make the same type of arguments under the provisions of the Department of Taxation and Finance to make a fee application. We think that we can, and then that there'll be a determination as to how much we're paid, and we'll go from there. It's a little quirky because they have an established rate that you can get. So even though, and the rate is a lot lower than what the rates are being charged by attorneys on average, including us. So you're not going to get it all back, but you might get some of it back. Let's put it that way.
Well, and part of the reason I wanted you to join me here is to not only talk about, a specific case that kind of highlights so much of what we as Native people face, but, there's also this argument oftentimes about whether we can pursue some sort of litigation or, or a lawsuit or against, the state or the federal government, or even frankly, a non-native, organization. I mean, a corporation or non-native individual. There's such a color about how law is looked at when it involves native people, native territories. I mean, an example that I'll bring up is, in the early years, there's a lot of people who assume that lots of native land was just ceded to the state. But much of the lands that were lost by native people, and this was really very true in Seneca territory, had to do with leases. And so Senecas individually would enter into leases for property to non-native lessees for, sometimes they would be 99-year leases, and in some extreme cases they were 999-year leases, which is really kind of absurd. And the problem with that is, for many years, for like 150 years, native people had no legal recourse. We couldn't sue a defaulted lease. We couldn't sue that lessee. So there was no recourse in the court systems. So even for us to seek some sort of remedy, for being wronged by an individual or a corporation or by the state, we had no ability to do that. And so this was the case for many years. Much of the lands that were lost through because people just said that their lease was like a sale, and courts and lawmakers upheld that, and we end up in situations, and I'm one of the things that frustrates me when we talk about land and land use. There was a circumstance where the Oneidas were purchasing land. The Oneida Nation was purchasing land in their ancestral claim area, a claim area that the Supreme Court had ruled that the Oneidas had the right to sue for fair title. But they had still not been granted any land back. So they purchased some of that land, and that case went all the way to the Supreme Court because the city of Sherrill was arguing that they couldn't reacquire their lost lands, regardless of how they were lost. And Ruth Bader Ginsburg, who was considered the liberal darling of the court at that time, she actually cited, and again, I have to bring this up, she's Jewish, and yet she cited the doctrine of Christian discovery in footnote number 1 of that argument that basically said once we were discovered, that the title to our land became vested in the sovereign, meaning Europe, the European nation, and then the United States and the individual states. They never describe how that happens. So they make these assumptions in law. And among those assumptions comes right down to something like the case you just tried, that the state assumes it has jurisdiction when they really don't have a place they can ever cite to say, well, this is when native people yielded our jurisdiction, yielded our sovereignty. We transferred our sovereignty to New York State. Look, I know that they passed laws. They passed Public Law 280 and US 232 and 233, but they don't ever have a place where they can say that we had become governed at the consent of the governed. I mean, we never consented to this stuff. So the assumptions that get made, and that's really the way New York State is operating. They're operating under the assumption that they can inflict and impose New York State law on our people, on our territory, or in any of this native to native trade. So I know I just got on my soapbox, but the part of the reason is to understand historically how far back this goes.
Yeah, well, I agree with you. I mean, it does. It goes all the way back, and it's a very imperialist sort of dogma that's been established that says that the sovereign is the owner of the land. But I agree with you that, especially in the case of the Seneca Nation, there was never any ceding of sovereignty by the Seneca Nation. The Seneca Nation was a party to treaties, and treated back then as a recognized nation. But those treaties, at some point were disregarded, and the role changed to the federal government being, it was a very paternalistic type of situation where the federal government took on the role of ensuring that, the tribes were not being abused by the states, but at the same time, they were affording the states more rights to do things on reservation territory. And it's really a miscarriage of justice the way this is all sort of played out in American history. I agree with you. I'm a firm believer that the Seneca Nation is a sovereign nation, and it has been. And it hasn't been conquered. It hasn't been displaced. It has been displaced from its traditional territories to where it is now. But it has that territory that it lives on, that it exists on, has always been Seneca territory.
It's important to acknowledge that that language in treaties that we didn't write, that they wrote, that they made those full acknowledgments. They said that land is yours and we will never claim the same, nor will we ever interfere in your free use and enjoyment of your land. So this is, and there's never been, again, we talk about a memo, that never officially gets changed. That language, there's no place in American history where New York State or the United States can say, okay, that land was Seneca land, but now we're going to count it. Now we're going to consider it U.S. soil. Now we're going to consider it, part of New York State. So I mean, it leaves us in a really tough spot because as we are trying to, and look, there's no question that today we essentially can assert ourselves with a little bit more force than we did, say, 30 years ago, 60 years ago, 100 years ago. We understand our what we consider our legal rights. The problem is we can't get a court to oftentimes weigh in on what those legal rights should be. We are simply relegated to finding ways that the courts can kind of save face and find a way out.
Correct. There's that, and there also is this idea of developing the economic strength of, in this particular case, the Seneca Nation, because if anything works in America or anything talks in America, money talks, right? So, with the advent of the casinos, with the advent of some of the other stuff that the nation has gotten involved in to develop its economy, and in the spinoff that creates in the Western New York area, it gives the nation more political clout to maybe, claw back some of the things that were taken from it in terms of the way the state views its sovereignty. So there's a political component to that too, that I think is enhanced the more the Seneca Nation develops its own economy, and in turn, that economy has some spillover effects off territory, so that there is an economic impact that New York State has to recognize and is forced to deal with the Seneca Nation more as a partner in development as opposed to a ward of the state, which is definitely the position that they've sort of been in, that, Seneca Nation exists within the borders of New York State, and therefore you're subject to New York State regulation. But, to the extent that you develop economic power, you can use that as political leverage to gain more rights.
We also talk about the court of public opinion, because with that economic power, we also, look, we have patronage. We have patronage from the non-native public, whether it's for casinos and gaming or for sale of gas and tobacco. And when we started this conversation, one of the things I think is clear, that the general perception of the public is that we have the right to do certain things that don't get done in the rest of the state. I mean, we can produce tobacco products. We can sell tobacco products. We can sell fuel, motor fuel, without New York State stamps or New York State tax on it. We can do gaming that the state perhaps has not been able to do. Of course, that's changed somewhat. But so there's that distinction is by and large acknowledged by, frankly, even by politicians. The problem is, once people get into positions of authority, they realize that they can wield power that they may not really have, because the system, and this is where we get into this idea of systemic racism. There's a level of perception that these people of power have, that the system's going to work for them and not necessarily work for us, and that's kind of where where we're at.
Sure. And it's a struggle for recognition, and it's a struggle to find an avenue or avenues available where you can successfully assert the sovereignty rights that the Seneca Nation and its people possess. There's a lot of history behind why New York State acts the way it does, but it does act like traditional imperialist powers when it comes to its dealings with Native Americans. That it's the power, and the nations are not as powerful, so therefore we can impose our will on them. And that's the unfortunate situation that we find ourselves in. But we'll keep making the arguments, and maybe one day we'll get a court to opine on them.
At some point, beyond might makes right has to prevail, and that's why we continue to push what we can push on our territories, and And we do ultimately, have to rely on, the arguments that that will prevail in court. And we hope that even if some of these judges have to find a few loopholes to slip through to not impose these fines or these, some of the sometimes criminal charges against us, at some point, there will be the political will to take a stronger stand. Because you mentioned earlier, look, we argue that much of what we face is not an issue that should be litigated. There should be political solutions to the issues that we have. But in the absence of any mechanisms, whether associated with the UN Declaration on the Rights of Indigenous Peoples or in just simple, diplomacy between Native peoples and the state, and Native peoples and the federal government. Look, there's oftentimes overtures made. Oh yeah, we're going to have a summit. We're going to have this. We're going to have that. But as far as meaningful change and any kind of full acknowledgement, we've got all kinds of language from treaties and past agreements that bolster our argument. But you're right. This oftentimes comes down to might makes right, and that's where we find ourselves all too often when it comes to both the state and the federal governments.
Yeah, and again, I hate to sound crass, but it also comes down to money, right? Because the state is aiming towards cigarette sales because the state believes that it's resulting in a deprivation of tax revenues because a lot of New York State residents are buying these unstamped cigarettes, native cigarettes, and therefore eluding New York State's taxing scheme. So therefore, that's the financial component that drives the engine. So again, we get back to the idea of, well, if you develop the economy of the Seneca Nation to a degree where there's more benefit in, looking away from the state of New York, pulling back and not enforcing or trying to enforce transactions involving Native American cigarettes because there's so much more economic benefit spilling off to New York State residents because the Seneca Nation is doing its a bang up job in developing its economy. And not only are New York State residents participating in that economy, but they're working for those companies, and there's all this spin-off. Then the calculus starts to change. You know what I mean? Yeah. And so it's a lever. Money talks.
But we do have to acknowledge that some of that's a bit of a red herring, because when we talk about how much revenue New York State is losing to cigarettes coming in from other states, for instance, if you really did the math, you would find the revenue that the state claims they're not collecting from our sales is really kind of it's pale by comparison when you look at places like New York City that have even city taxes on top of the sales and excise taxes at the state and federal level. So it's
I agree.
When you do the calculus,
the number they always float is way in excess of what the actual number is. You have to take it with a grain of salt. Anytime the state says this is how much our taxes are being avoided, you just can't go with that number. I agree with you.
Well, Jeff, I want to thank you so much for joining me here and having this conversation. I don't think our people realize, our Native people, and certainly the non-Native people, realize that this idea of the courts being the arbiters of justice, they really fall pretty short on that especially when it comes to dealing with Native issues specifically. And I think what you offered here in this program has really illuminated that a lot. So I really appreciate it.
Well, thank you for having me. It was a pleasure being on. Thank you.
Thank you for checking out the show. As always, if you like what you hear, you can support the show on Patreon at patreon.com/letstalknative. You can follow the show on Twitter at Let's Talk Native. You can also follow us on Instagram at Let's Talk Native TV. You can also join our Facebook group page. I am John Kane, and this is Let's Talk Native. Yahweh.
And that's the terrible myth of organized society, that everything that's done through the established system is legal, and that word has a powerful psychological impact. It makes people believe that there is an order to life and an order to a system, and that a person that goes through this order and is convicted has gotten all that is due him, and therefore society can turn its conscience off and look to other things and other times. And that's the terrible thing about these past trials, is that they have this aura of legitimacy, this aura of legality, because all tyrants learn that it is far better to do this thing through some semblance of legality than to do it without that pretense.